Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to talk to you about what you can do, what your attorney can do if you have a judge who will not connect the dots. And let me tell you what happened to me. I had a hearing recently before a judge who's a nice person, but I don't think he understands what it means to be a judge in the sense that he would not connect the dots. And let me walk you through the scenario. My client is 55 years old. She was 54 at onset, so right there you know that the grid rules could very well apply. She was diagnosed a number of years ago with a chronic kidney disease. Her kidneys do not function. She was originally stage 3, and prior to stopping work she became stage 4. And stage 4 kidney disease is the step before dialysis. It's pretty serious. She's also diabetic. She takes insulin, a lot of insulin. Her diabetes has been difficult to control. She's had heart problems. She's got 2 stents, coronary artery disease. She has COPD. She also does smoke, she says very few, 4 or 5 cigarettes a day, but she does have COPD, which definitely impacts her exertion. She has just a number of other medical issues. And one of the problems that she's got is that she's got a lot of weakness and numbness from the neuropathy from her diabetes. And so she's in a wheelchair. And when she stopped working, she was able to walk a little bit, but she needed an assisted device or a walker. And then she eventually progressed to the point where she's, for the last 6 or 7 months, she's been in a wheelchair. And literally, when at the hearing, we had to wheel her into the hearing in a wheelchair. Letty had worked for the same employer for 17 years. Stopped working in 2016, and when she stopped working, she just the reason she had to stop working was because the kidney disease. She had to go to the bathroom all the time. She was going at least once an hour, once every 2 hours. It was taking her 10 to 15 minutes to get things going, and so she was missing too many hours at work, and she was basically allowed to resign, partially because she'd been there so long. After she stopped working full-time, she got a job for a couple of months working part-time as a receptionist, 4 hours a day. That lasted about 2 months. Then she tried to work as an Uber driver, but that only lasted a month and a half or 2 months because her legs were numb and she couldn't sit for extended periods of time. This lady had lost over 100 pounds at her doctor's suggestion. And so she's very credible in my view. I mean, again, this is a person with a long work history who tried to work after her onset date. She has diagnosed medical issues. One of the issues I will tell you with the case is that she has no money and no insurance, so she can't go to her specialist anymore. And occasionally she runs out of medication. At times she doesn't have her insulin. And she's got adult children who help out as much as they can, but they can help buy her insulin. But her son was telling me it's $400 a month. And they just don't have the money to keep doing that. And she really needs physical therapy because of the numbness in her legs. She falls down. In fact, she was at a rehab facility for 3 months just to try to regain some strength in her legs, which was not successful. So again, picture this. I'm walking into the hearing. I'm wheeling my client in a wheelchair. She's testifying about her urinary issues, the urgency as well as the time in the bathroom and the frequency. She's testifying that she has no feeling in her legs, her feet, her left side, her left arm because of the diabetes. She's testifying that she doesn't always have the money to buy insulin, and that sometimes her blood sugar will just spike out of control, that she's lost weight at her doctor's suggestion, she's doing everything she can, she tried to work, she can't do it. Yes, she does smoke, the judge did point that out, but she says, I've cut back, I was a pack-a-day smoker, now it's maybe 5 or 6 a day, but it's just very, very hard for her to quit. Okay. So my view is you've got a very credible claimant, and the medical records after the past year and a half, there's not much because she ran out of insurance, but we do have several ER visits where the ER doctors are basically saying this lady is, her blood sugar's out of control, she's got terrible neuropathy, her kidney disease is not getting any better, and that she's clearly in a lot of pain, a lot of discomfort at times. She has breathing issues, sometimes shortness of breath. So she does go to the ER when she can, probably 2 or 3 times in the last year and a half. So that's sort of the scenario. In my view, and she's 55 years old now. She was 54 basically at onset. So again, I think that, even if the judge didn't want to deal with the medical issues, could certainly conclude this lady's limited to sedentary work. Well, after taking testimony, and I gave a pretty strong opening statement, after taking testimony, the judge looks at me and says, well, I don't really see anything in the record to suggest that your client's level of impairment is as bad as she says. I said, well, Judge, stage 4 kidney disease is not really a joking matter. I mean, that's the step before dialysis. I mean, it's clearly there's problems with the kidney function. I mean, her liver enzyme tests and liver and kidney enzyme tests are not are out of range. The doctors talked to her about dialysis. Well, but there's nothing really talking about that she needs to be in that wheelchair. I said, well, Judge, person working in the same job for 16 years and basically left because she had to and tried to work 2 jobs after that, I mean, I don't think she'd be in a wheelchair if she didn't have to. And she's testified that she doesn't have any strength in her legs. We've got diagnosed diabetic neuropathy, and we didn't even get into the retinopathy, the floaters and so forth in her eyes, but she's got a diabetic neuropathy. Clearly she can't feel her feet. Is it unreasonable to assume that she might need to be in a wheelchair, and that she's not in a wheelchair because she wants to be? And she talks about it, and she even testified how embarrassing it is that she needs help getting on and off the toilet. She needs help, and she's got 3 sons. Her sons have to bathe her. I mean, again, this is a 55-year-old woman whose sons are having to bathe her. And I'm sure that's not the most pleasant thing in the world, that she can't really do anything around the house. She's basically bedridden. She falls asleep during the day. She doesn't sleep well, and she has no money for medications. I said, this is not a person who's living a great life, and I think her testimony is very consistent with the medical evidence. Well, counselor, I just don't see that. I just don't think that there's really any suggestion that her feet and her legs are numb and that she needs to be in a wheelchair. So at this point, it's obvious to me this judge just doesn't want to connect the dots. And again, I don't think he's a mean guy, but maybe he just wasn't properly trained. But again, I think that it's reasonable to think that somebody with stage 4 kidney disease is going to have some bathroom issues. I think it's reasonable to think that somebody who's been a diabetic for 15 plus years and who's on insulin that is poorly controlled is going to have neuropathy when it's diagnosed in the record, and that because of the neuropathy there could be numbness in the hands and the legs. But this judge didn't want to connect the dots. So where I was faced with was, obviously I didn't want the case to get denied, so I said, well, Your Honor, maybe since the medical's she hasn't been able to afford to go to the doctor, maybe what we should do is send her out for a consultative evaluation. She already had one, but we'll send her out for another one that might help Your Honor feel more comfortable with what she's saying. Well, okay, counselor, what kind of doctor? I said, well, since she's got stage 4 kidney disease, a nephrologist would be the logical choice. Well, I don't think we can do that. I don't think we can get her to a specialist. I said, well, an internist, certainly somebody who understands kidney function, would be sort of our second choice, but I think a nephrologist would be better. Well, I'll send her out for a consultative with an internist. Okay, I said, well, Your Honor, maybe what we should do here is that if we're going to have, since we're sending her out anyway, maybe we should have a second hearing and have a medical expert come. And the medical expert can maybe help connect the dots and help you understand more about whether her testimony is consistent with what the medical evidence says. Well, that's a good idea, and I give the judge credit for that. We'll do that. We'll go ahead and schedule a supplemental hearing and have a medical expert here, either by phone or in person. And meanwhile, we'll send her out for a consultative, and let's see if what the medical tells us something differently. But I still, right now, I just don't see it. So, okay, again, I give the judge credit. He was open-minded enough to send her out for a consultative, open-minded enough to schedule another hearing, but that's how I handled it. So even though, because basically the judge was telling me he wasn't going to approve the case, so I felt like I believe in my client. I think she's telling the truth. So again, I just said, well, let's do a supplemental hearing. Let's get a medical expert in to help connect the dots, and we'll see what happens. And again, no guarantees, but this is a case I think that 85-90% of the judges that I wouldn't go in front of would recognize this lady is clearly disabled. I mean, again, if anything, the grid rules, because she's in a wheelchair, she's not going to be able to, and she also, by the way, I didn't even mention, she had neck surgery, a 4-level neck surgery in the past, and she can't turn her head from side to side, and again, maybe some of the numbness and tingling is reflective of that. So this lady's a real mess. I think she's believable. I think she's telling the truth, and I just don't think she'd be in a wheelchair with her adult children, her adult male children, helping her bathe herself and dress herself and get off the toilet if there wasn't something really going on here. So that's my take on it. But bottom line is, that's what I did. And you may find yourself with a judge, and that's why I always tell people, go to disabilityjudges.com and look up the approval denial rating of the judge. And if you have a judge who doesn't approve many cases, this might be a situation where you prepare for that eventuality, so that you can, your attorney can certainly ask for a supplemental hearing or a post-hearing consultative evaluation. Something else that I probably would do next time, and I'll do, is I suspect there are some Social Security rulings, and this is more of a legal thing, where it talks about the rulings where Social Security has issued legal guidance to judges and adjudicators about how to connect the dots. And I'm going to try to find one that really says to the judge, it's reasonable to assume that somebody's telling the truth if you have this medical evidence here and symptoms testified here, and maybe we can get this judge to sort of change the way he evaluates cases. So anyway, I thought you might find that interesting. Very frustrating day for me, because again, I thought this was a clear winner. I still think it's a clear winner, but we'll see what we can do. And of course, my client or her sons asked me after the hearing, do we have any recourse? I said, other than moving to another place in the city, we'll be associated with a different hearing office. Not really. And so they can't really move, so they're basically saying, well, we just have to take our chances. I said, yeah, I'll do my best to try to fight this, but we've got a judge who just doesn't seem to understand that the word judge is a noun and a verb, that you read the medical record, but you have to make judgment calls. Is somebody telling the truth? Is it reasonable? And like I said, we've got a very nice gentleman as a judge, but I don't know that he's doing what he should be doing in making that connection, which is a logical connection, at least in my view. So let me know what you think. Have you had judges like this? You run across people like this? What would you do? Do you think my approach was the correct approach? Was there anything else I could have done? If you're an attorney, any other suggestions about what I can do? This is still an ongoing case. What else can we do to try to get this lady the benefits she clearly deserves? Please let me know in the comments, both on Facebook here and on YouTube. If you like this video, please give it a thumbs up on YouTube and like it on Facebook. Like our Facebook page. Subscribe to my YouTube channel. Again, leave me a comment. And if I can be of assistance to you, please reach out to me. Happy to help you any way I can. My name is Jonathan Ginsberg, and I appreciate your attention to this video very much. Thanks a lot. Bye-bye. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.